Hello and welcome to News Center. The big story we are tracking: in an unprecedented move, the Supreme Court has ruled that criminal charges against the Sandesara brothers can be dropped if they pay the full and final 5,100 crore rupee settlement. This after Nitin and Chetan Sandesara's lawyers said this is about getting rid of all proceedings and not an admission of guilt. On several occasions in the past, the brothers have rejected these allegations. Meanwhile, they have paid 3,508 crore rupees so far and have been asked to pay the rest by the 17th of December. Let me break it down. The Sandesara brothers were accused of defaulting on bank loans worth 5,383 crore rupees. Their one-time settlement was originally set at around 6,761 crore rupees, but after negotiations, the CBI agreed to settle at 5,100 crore rupees. Some fear this could set a precedent, letting big economic offenders away by just writing a cheque. Joining us now to take this forward is Vijay Aggarwal, Supreme Court advocate. Mr. Aggarwal and Advocate Aditya Pratap are also with us on the program. Vijay Aggarwal, if I can come to you first, does this set the right precedent? Now, we're talking about a huge economic fraud. To let go of people in this manner, the government lawyer, by making this proposal in a sealed cover to court, saying that if 5,100 crores is deposited, then the case can be put to an end. Is this the right way forward? Because it's quite possible that other economic offenders, fugitives, may take the same recourse in future.
See, the judgment very clearly says in Roman 7, and it is para 12 of the judgment, that this judgment will not be used as a precedent. This is your first answer. That this judgment cannot be a precedent because it is specifically, emphatically stated by the Supreme Court that this judgment cannot be cited as a precedent. This is one. Two, if you ask me my personal view, I consider it a very, very welcome step. And it is not as if that it is being decided now. See, there are two kinds of offenses. One is an offense against the property. One is an offense against the body. Recall Union Carbide case. In 1989, 4 judges bench Supreme Court had said that the criminal proceeding will not continue. But then it was reviewed by the Supreme Court by 5 judges bench in 1991. And they said that Supreme Court under Article 142 has the power to quash, but they did not quash it in the facts of that case because there was the loss of life. But somehow I feel that when it is an economic fraud and the bank's money have been taken away, so the banks are running after. So if ultimately the person is settling, and this is the practice world over, in India also, they call it plea-bargaining, but that is for the smaller offenses. So it should happen. And can I tell you, every day we see the compromise settlement happening, even in rape cases. Initially, the girlfriend comes and says, oh, my boyfriend is not marrying me. I want to lodge a rape case. The boyfriend goes to jail. And later on, the boyfriend marries, and then they run to the court that please quash the case.
Okay.
And you know, every time
let me just get in.
The case is quashed.
Mr. Aggarwal, I'm going to bring in the other panelist on our show, and I'm going to return to you. Aditya Pratap, does this make way for fugitives like Vijay Mallya, Nirav Modi, Mehul Choksi to take a similar plea in future?
See, first and foremost, to begin with, the Supreme Court has clearly held that this case will not serve a precedent. Now, in principle, I do not agree with the stand adopted by Mr. Aggarwal and the reasoning given by him. However, when we take a larger view, Supreme Court is faced with the dilemma of recovering money out of the cold. We are dealing with a case of a fugitive economic offender who has literally fled India and gone to a place like Nigeria. So Supreme Court is also seeing it from the face that we have to literally recover the money out of the cold. Now, if you look at the settlements which have happened in NCLT, look at the steep haircuts which banks have taken, 80%, 90%, almost the entire amount has vanished. So if the Supreme Court is of the opinion that the settlement amount offered is at least a decent consideration, something which is recoverable, then probably, in principle, I would agree with the wisdom of the Supreme Court, because if you look at the history of these, because see, this is a case of a willful default. The case of the Sandesara brothers is of people who have vanished with public depositors' money. And I say the accountability acts should not only be on the Sandesara brothers, but also on the officials of the public banks who allowed such loans to happen in the first place. Now, so what happens is Supreme Court, because the Sandesara brothers apparently have filed a petition, And you know, like in law, because in law, whenever financial disputes happen, we lawyers do tend to take a slightly pragmatic stance because lawyers as such are not recovery agents. Now, obviously, like ultimately the banks can invoke the recovery proceedings. But when you look at the other proceedings where 90% haircuts are taken, probably the Supreme Court is of the opinion that that a certain fair amount of not fair, but at least a certain respectable amount can be recovered by way of this. Because remember, we are dealing with the case of an offender who has literally funneled the case into offshore jurisdictions, from where tracking and getting bank account holders' money back probably might involve exponential difficulties. And of course,
Right.
so on these points,
Okay.
yeah, so which is why, even though probably I do agree that they need to be punished. In fact, not just them, I believe that the corrupt bank officials who facilitated such
Okay.
loans ought to be punished.
Aditya, just stay with
And that
us.
too because
My
they
final
teach public
question to
trust.
Vijay Aggarwal. Mr. Aggarwal, what I'd like to understand from you, you've represented Nirav Modi, Mehul Choksi in the past. Even though the Supreme Court has said that this is not a precedent, but considering the government has made a plea and made a proposal in a sealed cover, would you somehow try and take the same recourse to end the criminal cases against them?
I don't think my clients whom you referred, my current clients or ex-clients whom you referred, after so many years of litigation, they are left with that kind of a money. And my colleague said that if the whole money is being recovered, it can be settled. So in a way, he is agreeing that if the whole money is getting recovered, it should be settled so that the banks ultimately get the public money. So what is the interest in just prosecuting them? And tell me in which cases? Now we are saying, though, the case is over. What has happened in Nirav Modi case? The case has not even started. What has happened in Mehul Choksi case? Case has not even started. What has happened in Vijay Mallya case? Case has not even started. So you want to keep the case hanging in your drawing room and you say that, okay, now we have a painting on the wall which is useless. So it will keep it is in a photo frame. But ultimately nothing happens. So I said it is a welcome chat. If the banks are getting money, there I am agreeing that the bank should not be taking a haircut or a smaller haircut. So if the banks are getting their total money, public money is coming, you do not have the infrastructure and the courts enough to try a person. Trial takes ages. In a 2G trial took 7 years where I represented. A day-to-day trial, it took 7 years. So where is the trial? In Mumbai, trial doesn't even
Vijay
start.
Aggarwal, Aditya Pratap, I've completely run out of time, but thank you very much for joining us on this program. But clearly, this will be a legal debate going forward. I'd like to shift focus to India's new